I would like to officially invite the moderator for today's debate, Mr. Waqas Mir. He is an advocate of the High Court. He holds an LLM from Harvard Law School, and he's a partner at Access Law Firm. Sir, over to you.
अस्सलाम वालेकुम जी, मेरा नाम वकास मीर है और मैं लाहौर में वकालत करता हूँ. I'm delighted to be in conversation with such an esteemed panel today about such an important topic that we talk about in our conversations and in our courtrooms quite often. One by one, I'll invite members of the panel onto the stage. Our first guest today is Mr. Salman Akram Raja, who's an advocate of the Supreme Court and senior partner at Raja Mohammad Akram. Mr. Raja has litigated many important constitutional law cases. He has taught law, he has written about the law, and continues to be an important and influential voice in newspapers and television screens. He's a graduate of Cambridge, SOAS, and Harvard Law School. Thank you, Mr. Raja, for being here. Our second guest today is Mr. Mansoor Usman Awan. He's a litigator who specializes in constitutional law and tax law litigation. Mr. Mansoor Usman Awan is an informed and important voice when we talk about politics of the judiciary and the makeup of the judiciary. He is a graduate of Harvard Law School and he worked at Fried Frank in New York, and we're really grateful that he's here. Thank you. Our two other guests who are not here yet, but we'll have to start without them, are Mr. Hamid Khan, who, as all of you know, is a senior member of the team at CLM, and he has written about the Constitution, about the judiciary, about the political history, and has litigated many important cases at the Supreme Court. And Justice Nasra Iqbal, who served as a member of the judiciary from 1994 to 2002. When they come here, we'll involve them in the debate, but I'm just going to start off the debate with asking Mr. Raja the first question. So with your permission. And we're also joined here today by Mr. Khwaja Mohsin Abbas, who's the Secretary of the Lahore High Court Bar Association. So, sir, if you could please join us. Thank you so much. Thank you so much for being here. So, Salman sir, मेरा पहला सवाल आपसे है that, and this flows from the recent talk of the appointment of Her Ladyship Justice Aisha Malik to the Supreme Court. We're far away from the days where where we can talk about a gender balance in our courtrooms. But do you think gender diversity is important when we talk about elevations to the Supreme Court? And why is that? And why hasn't that been present to the minds of people making these appointments?
Yeah, obviously, gender diversity is important. I think there are no two ways about it. And whatever field of life you look at, whether it is legislation, whether it is politics, it is clear that women have a distinct voice and a distinct way of looking at the world, which, unless they are present, does not get articulated. And within the judiciary also, it is very clear that the law means something different when it is interpreted and looked at by a woman compared to when it is interpreted and looked at by a man. That is a very clear distinction in life. We approach things from our own individual standpoints, and those standpoints to a significant extent are impacted by both gender, class, background, but gender remains key to our sense of identity and how we look at the world. So that is clearly important. But your question really, I think, has to be placed in the larger context of the conversation that we are having today, that should she be elevated only because she is a woman in order to create gender diversity in the Supreme Court? Then the answer, obviously, as far as I'm concerned, would have to be no. And I am generally standing for the position that nobody should go to the Supreme Court because of some formula. Whether the formula is seniority, and seniority is nothing but a formula. It says, look, we will not look at what this person has done as a judge for 8-10 years that they've served on the High Court. We will just look at the date of appointment. And if the date of appointment makes somebody senior to somebody else, then that person goes through, and whatever they might have done as judges loses significance. Similarly with gender, I'm not going to say that you should have some boxes which say which says that so many women must be there in the Supreme Court at any given point in time, and if that number of women is not achieved, you just look for a woman and you take her to the Supreme Court. That would be wrong again. The Supreme Court of Pakistan has to reflect, our values. It has to reflect what we as a people believe in about the law. And that is something that can only come about as a result of a process of deliberation at some level. Simply leaving things to chance, leaving things to seniority, the date of appointment of somebody, or in case people are appointed on the same day, their dates of birth, is the most ridiculous, to my mind, way of constituting a Supreme Court of any country. Nobody does that. We have several Supreme Courts that have come into existence in the last 20 years. You look at South Africa, you look at the UK Supreme Court, that is the successor to the House of Lords, and everywhere this debate has happened. How should people be appointed to the Supreme Court, the apex court of the land? And nobody anywhere has suggested that this should be simply a conveyor belt which takes people from the High Court to the Supreme Court only on the basis of seniority. Seniority is no principle at all. It can be at best a device, but it is not a principled position at all. So the question that then arises, are we capable of making principled decisions? And I think what the other side is saying, and I've had this conversation with Salahuddin of the Sindh High Court bar in the press and in person, and with Hamid Khan Saab in person, their position simply boils down to this, that we do not trust the people making decisions for us at the level of the Judicial Commission. Because we do not trust the people who make these decisions, therefore we wish to take discretion, decision making away from them, and we wish to institute a process whereby nobody really has to make a decision. The dates of birth or the dates of appointment produce the decision. Now this really is a very sad state of affairs at two levels. One, the conception that we have of our decision makers in the Judicial Commission, let us say to begin with, and secondly, the conception that we have of our own role as lawyers in society. I think at both levels this is a defeatist position. It presumes that the Judicial Commission cannot be improved, that we do not have the capacity to engage with the Judicial Commission, that we do not have the capacity to launch a critique, to examine, to protest, and therefore the Judicial Commission will always have its say, and the Judicial Commission, dominated by judges, will always somehow produce the wrong decision under pressure or because they have favorites that they wish to elevate. Now, to my mind, this may be a reality. It may be true that the Judicial Commission as constituted is not the ideal body, that we need to change the way the Judicial Commission is constituted. And indeed, the 18th Amendment, if you recall, had a very different Judicial Commission. And the Parliamentary Committee had a very different role from what they've now come to exercise. The original Judicial Commission, created by the 18th Amendment, did not have a majority of judges on it. It had representatives of the bar, it had people from the government, it also had a possibility of people from civil society serving on the Judicial Commission. Now that Judicial Commission was challenged in the 18th Amendment case, and ironically it so happens Hamid Khan Saab was the lead counsel challenging the 18th Amendment and asking for the adoption of the basic structure doctrine to even strike down the 18th Amendment or those parts of the 18th Amendment that had created the Judicial Commission. I had appeared in that case in 2010 on behalf of Hasil Bazinjo, Aige Rehman, Abid Minto, and we had said as interveners that you should not touch the 18th Amendment. This is something that Parliament has done. If it is to be amended, it will be amended through Parliament. We do not want you to hold Parliament at gunpoint and ask Parliament to do another amendment that you prefer. But that is what happened ultimately. So the Supreme Court effectively announced, and I'm a party to that, I'm an eyewitness to that moment, and I could not believe it when the court was saying, you go away, take this to Parliament and amend it. The Judicial Commission should have a majority of judges on it, and unless you do that, we will strike down the amended Article 175. And that is what happened then. Parliament, under that pressure, convened, the 19th Amendment was passed, the composition of the Judicial Commission was changed, and the judges of the Supreme Court were given predominance within the Judicial Commission, which was completely contrary to the original intent of the 18th Amendment. And then a year later, the Munir Bhatti case came, which completely took away whatever role the parliamentary committee had. So the original conception of the 18th Amendment was that we would have a deliberative process in which members of parliament representing the people of Pakistan would have a say, in which judges would have a say, but not an overwhelming veto power, and there would be representatives of the bar and of civil society who will all look at the merit of a particular candidate, a particular nominee for elevation, whether to the High Court or to the Supreme Court, and society would thereby get involved in this process of elevation. We destroyed that process deliberately, and the bar unfortunately has a role to play. It was the, I think, Rawalpindi District Bar Association that had challenged, and several other bar associations had challenged, and at that time in the courtroom the slogan used to be "Chief Tere Jaan Nisar Beshubar," this Judicial Commission that is taking away power from you, Sir Iftikhar Muhammad Chaudhry, we will not tolerate such a Judicial Commission. So what we did then was, we played to the moment. We played to our own gallery that we had set up. We were so taken up by the lawyers' movement, of which we all were a part. We all went to jail. We were all beaten up. But the point, the principle that we gave away in that euphoria was a most serious one. So in upholding Iftikhar Muhammad Chaudhry's authority, we forced upon this nation the 19th Amendment by going there as bar associations and asking the Supreme Court to strike down the 18th Amendment. I think was not a wise thing to do. It was against the papers that the Supreme Court Bar, the Pakistan Bar Council itself had written during Sheikh Riaz's tenure, asking for a commission to be set up, a broad-based commission to be set up for appointments to the superior judiciary. And when that commission was constituted, we said we don't want that commission. We want Iftikhar Chaudhry to be the supreme appointing authority. And that is what you got after the 19th Amendment and the Munir Bhatti case. We effectively played a role in undoing the 18th Amendment. Now I think we are again doing the same thing. We don't like what is happening today. We think Qazi Faiz Isa is being targeted. We think there is a curative so-called review pending. We think there is an attempt to pack the Supreme Court, to bring in judges who will deliver a judgment which the establishment likes. There is going to be another full court hearing in due course next year sometime. So the suspicion, the worry today is that whatever is happening in order to create a Supreme Court that will be compliant and that will enable the powers that be to get rid of Qazi Faiz Isa Saab. Now that is completely possible, and I do not discount that possibility that that is indeed what may well be happening. But we have to take a step back and ask ourselves that in dealing with this situation, are we going to impose on our constitution, on our framework of the judiciary, a so-called principle of seniority that ultimately will come to haunt us and hit us badly? I invite you to just look at who would have come to the Supreme Court in the last 10, 15 years if the seniority so-called principle, I don't accept it as a principle, it's a device. If the seniority device was accepted, I don't need to take names. Just look at the Chief Justices of the Lahore High Court or of some of the other high courts over the last 8-10 years and see which one of them we would want to be in the Supreme Court and which ones we would not want to be in the Supreme Court, and who are the ones who would reach the Supreme Court had this principle been followed or if it were to be implemented today. And what turns out, I've done that exercise, is a disaster. Okay, a Supreme Court judge does various things. A Supreme Court judge does not just decide political cases. Each time there is a political disruption, there is a PCO, or there is an assembly in crisis. A Supreme Court judge also decides cases about women, about minorities, and that ultimately is, to my mind, at least as important, if not more important, in constituting the fabric of our society. one of my earliest memories as a young lawyer in the early 90s was of the senior puisne judge of the Lahore High Court hearing a bail application. Now, the bail petition was of a child, a 10-year-old, I remember, and his lordship asked, is this child, he mentioned his sect, Maslak, does he belong to that firqa? And the counsel said, yes, my lord, he does. And he said, bail dismissed, evil should be nipped in the bud. Now, this gentleman, who was the senior puisne judge at the time, would no doubt have made it to the Supreme Court had the seniority principle been followed. The seniority principle took Justice Irshad Hasan Khan to the Supreme Court. The seniority principle or device, as I call it, took Sheikh Riaz Ahmed to the Supreme Court. So what has the seniority principle prevented? I know in our earlier conversations, people have mentioned, Khan Saab has mentioned, that Munir Saab was appointed Chief Justice of the Federal Court out of turn. Now, we are not talking about the Chief Justice here. As far as the Chief Justice is concerned, Asad Ali's case has laid down the rule that the senior most will be the Chief Justice. So that is not the issue that we are confronting. We are looking at elevations from the High Court to the Supreme Court. Now, which elevation in the past has the seniority principle prevented elevation of people that I just mentioned, who we often now cite as collaborators, as people who did much to harm the principles of democracy under the Musharraf regime? They had come to the Supreme Court as the senior most from the High Court. So to say that if you adopt the seniority device, somehow that will automatically create a better Supreme Court, a Supreme Court that is less beholden to the establishment, to the powers that be, which will be more independent, I find no evidence from that when I look at 74 years of history. As many collaborators have come to the Supreme Court on account of seniority as have been handpicked by the powers that be to bring to the Supreme Court. So that really is no argument at all. So my position is that, look, it is our responsibility as lawyers, as bar councils, bar associations, to engage with the Judicial Commission and to demand that the Judicial Commission become a more representative body, a more inclusive body, that the dominance of the judges should be done away with, that there should be other voices who should have a role to play, an effective role to play in the Judicial Commission. And that is what we should be fighting for. We should examine each particular nomination, whether it is Muhammad Ali Mazhar, whether it is Justice Aisha Malik. We should challenge and engage with those names if we find something objectionable. And the process of engagement cannot be done away with for any reason by saying, if you have seniority, we would not have to engage. Then what are we there for? What are we guarding as bar councils and bar associations if we are not going to guard the entry into the superior judiciary? So my position is that it is our utmost duty to not fall for some kind of a device like seniority. We need to remain engaged. Democracy is a process of deliberation, of debate, of argumentation. Democracy is not about creating algorithms and putting down devices which make the system self-operating. Democracy is not a self-operating system. Democracy and constitutionalism are about engagement, debate, conversation, view and counter-view. And we cannot give up on that. As lawyers, to say that we do not want a process of deliberation, we simply want some kind of an algorithm to decide who is going to be a judge of the Supreme Court, is a defeat of the spirit and is a complete negation of what the Constitution stands for. Even, just last sentence, even after the 19th Amendment, the Constitution is not saying the senior most will come to the Supreme Court. Then why would you have a Judicial Commission? Why would you have a parliamentary committee? You would just need a one line. How can we as lawyers demand the imposition of an interpretation on the text of the Constitution that the text will not carry? If we accept this principle that our wishes, our demands should be the Constitution of Pakistan, then we lay open a very, very dangerous path. Other powers will want their wishes to be the Constitution of Pakistan as well. So we have to be faithful, and there are well-known principles of interpretation. Clearly the text is amenable to interpretation and there is flexibility, but you cannot go to the extent of completely washing away what Article 175 is saying. Article 175 even today is not saying that the senior most from the High Court will become judge of the Supreme Court. How can we impose that on the Constitution while remaining faithful to the Constitution. Let's ask for an amendment to the Constitution. Let's say the Constitution should adopt the seniority principle. But as long as the Constitution has not done so, we have no option but to engage with what is there and to raise our voices in an informed manner to prevent the powers that be, the establishment, from polluting the judicial system of Pakistan. Thank you.
Okay, thank you. So Mr. Hamid Khan Saab is here. If I could please ask him to join us on stage. Mr. Hamid Khan Saab is a senior advocate of the Supreme Court of Pakistan. He is a senior partner at SaleemYaqoobLL.M and has over 50 years of experience writing and litigating very important issues regarding Pakistan's constitutional and political history as well as judicial history. He has held important offices in the bar councils as well as bar associations. Sir, if you could please join us on stage and contribute to the debate. Thank you. So, खान साहब, मेरा अगला सवाल आपसे होगा कि राजा साहब ने अपनी पोजीशन बयान की है कि सीनियरिटी प्रिंसिपल से वो इत्तफाक नहीं करते। आप पाकिस्तान की सियासी और आईनी तारीख के बारे में लिख चुके हैं और अक्सर हम सब आपसे बहुत सीखते हैं इस बारे में। तो अगर हम सीनियरिटी प्रिंसिपल को अबैंडन कर देते हैं तो आपके इस बारे में क्या तहफ़्फ़ुज़ात हैं और क्या वो ख़दशात हैं जो आपके ख्याल में हमें मद्देनज़र रखने चाहिए? अगर आप कुछ मिनट में वो बयान कर सकें। शुक्रिया।
थैंक यू सो मच जी। देखिए, एक तो बात मैं आपको क्लियर करना चाहता हूँ फॉर एवरीवन, ये जो व्यू पॉइंट है ये कोई इंडिविजुअल का व्यू पॉइंट नहीं है, ये आज पाकिस्तान के सब वकला नुमाइंदगान का व्यू पॉइंट है। ए कंसेंसस हैज़ बीन रीच्ड इन कराची और इन मुल्तान, वेरेवर वी मेट, कि सीनियरिटी शुड बी द मेन criterion for elevation of the judges of the Supreme High Court to the Supreme Court. So therefore, individuals can have their viewpoint. We must respect the collective viewpoint of the lawyers as a whole. So yahan se I am going to start with this. Now coming, you are absolutely right. Arguments have to be made. We all lawyers, we make arguments either way, this way and that way. This is something we do all the time. You want me to speak in English or Urdu? Thank you so much. Thanks a lot. Thanks for inviting me over here, because I did remember vaguely that somebody asked me I should come around 2 o'clock on Saturday for such a debate, but later on there was hardly any follow-up, and today I was, except for Rabia Bajwa, she called me and said that you are expected over there. You see, the thing is, let me explain one aspect. Arguments are made on all sides, because I see mostly lawyers. Argument can be made in the air. Arguments can be made on the basis of certain substantive grounds and experiences, which we call the empirical reasons for doing it. Maybe an argument is very substantial in USA but not in Pakistan, because everything has to be related to the very background or to the very historical context. We in the subcontinent have a particular kind of judicial experience, whereas many others in different systems have different kind of experiences. We cannot argue just in the abstract or in a void. We have to argue and consider things in the context of the country, the people, the judicial system that we have. So in the first place, I'll just demonstrate it before you, all of you, that ignoring the seniority principle in the history of Pakistan has proved to be disastrous. And why it has been disastrous, that is a question that will come into your mind, because the consequences that flowed out of it. پہلی دفعہ پاکستان کی تاریخ میں سبسٹنٹیو زیادتی ہوئی تھی 1954 میں 1954. At that time, the Supreme Court was known to be federal court under the 1935 Act. The vacancy fell when Justice Abdul Rashid retired as Chief Justice of Federal Court of Pakistan. Now the question was, who should have been appointed as the Chief Justice? Obvious choice was Mr. Justice Abu Saleh Muhammad Akram. The difficulty with about appointing him were for the establishment even at that time in West Pakistan. Today the establishment is very powerful. Even then it has started becoming powerful. A Bengali was not acceptable as a Chief Justice of Pakistan at that time. They said that he may not follow what we want him to say. انہوں نے پھر یہ کیا کہ اس کو اگنور کر کے ان اے وے ایک پورا پلان بنا کے اس کو مجبور کیا کہ وہ خود کہہ دے کہ جی میں نہیں مانتا، آپ کسی کو بنا دیں. یعنی ایک نوٹ پٹ اپ کیا گیا کہ ہم کسی لا لارڈ کو کیوں نہ بریٹن سے بلا لیں، اس کو اپنا چیف جسٹس بنا دیں. تو اس سچویشن کو سامنے رکھتے ہوئے انہوں نے کہا کہ بھائی خود غلام محمد صاحب کے پاس چلے گئے اکرم صاحب. انہوں نے کہا بھائی آپ نے 100 سال غلامی کی ہے انگریزوں کی، ہم نے 200 سال کی ہے. بنگال میں ہمارا بڑا تلخ تجربہ ہے. خدا کے لیے ایک دفعہ پھر انگریز کو امپورٹ نہ کریں یہاں پر ہمارے سروں پہ بٹھانے کے لیے. اگر میرے ساتھ کوئی مسئلہ ہے آپ کا تو میں چھوڑ دیتا ہوں، آپ جس کو چاہے بلا دیں. See the way he was trapped. وہ ہی was such a good پاکستانی کہ وہ کہتا تھا پاکستانی کو بنا دے پر آپ کسی انگریز کو نہ بنائیں. انہوں نے وہ تو اسی انتظار میں تھے غلام محمد صاحب کہ یہ کوئی یہ کہے تو میں منیر کو، جو اس وقت سپریم کورٹ کا بھی جج نہیں تھا، ہائی کورٹ کا جج تھا، he was چیف جسٹس آف لاہور ہائی کورٹ، وہاں سے اسٹریٹ اوے پک کیا اور اس کو چیف جسٹس لگا دیا. اس کے بعد جو فالو ہوا ہے وہ آپ اچھی طرح سمجھتے ہیں کہ منیر کورٹ نے اس ملک کے ساتھ کیا کچھ نہیں کیا. اس کے فوراً بعد مولوی تمیم الدین خان کیس آیا، اس میں جو کچھ ہوا ہے مجھے جانے کی ضرورت ہے. آپ سب اسٹوڈنٹ آف لا رہے ہیں، آپ سب کو پتہ ہے کہ پاکستان کتنی بڑی زیادتی ہوئی تھی. اس وقت کی اسمبلی کو ڈیزالو کر کے تقریباً تیار شدہ کانسٹیٹیوشن کو ریپ اپ کر دیا. اور یہ ایک واقعہ ہر آدمی آج بھی کہتا ہے کہ منیر کی اپوائنٹمنٹ اور منیر یہ مولوی تمیم الدین خان کیس اور دوسرا 200 کیس کی وجہ سے پاکستان کی جوڈیشل ہسٹری میں بہت بڑی زیادتی ہوئی ہے اور بہت ڈی ریل پاکستان اس دن سے ہو گیا، جمہوریت کے حوالے سے بھی اور اس کے علاوہ جوڈیشری انڈیپینڈنٹ جوڈیشری کے حوالے سے بھی، کیونکہ اس دن سے یہ بائی آن کنسلٹیشن آپ ججمنٹس لینے لگ گئے ہیں. اب جو چاہتے ہیں مقتدر قوتیں، اس وقت کی مقتدر قوت جس کی نمائندگی غلام محمد صاحب کر رہے تھے، انہوں نے وہ ججمنٹ لی ہے جو ان کی مرضی کی تھی. جب مارشل لا لگا 1958 میں تو مقتدر قوت جو اس وقت کی تھی جنرل ایوب خان، اس نے ان سے ججمنٹ لے لی کہ ہاں مارشل لا بالکل ٹھیک ہے. 9 سال کا بنایا ہوا آئین ہمارا، 9 سال کا کی محنت کے بعد ایک آئین بنا تھا جس کو مشرقی اور مغربی پاکستان دونوں نے قبول کر لیا تھا. وہ اس میں ایک بیسک فلا تھا کہ اس میں پیریٹی کا پرنسپل لے کے آئے تھے، برابر برابر ہماری ان کی ریپرزنٹیشن تھی. لیکن سہروردی سے کسی نے پوچھا کہ بھائی آپ کیوں مان گئے ہو، مشرقی پاکستان کی تو 55% آبادی ہے اور مغربی پاکستان کی 45% آبادی ہے، آپ نے کہا کہ ہم برابر نمائندگی لے لیں گے. تو سہروردی صاحب کا کہنا بہت تاریخی ہے. انہوں نے کہا بھائی ہمیں تو انہوں نے 1% بھی کبھی نمائندگی نہیں دی. مغربی پاکستان کی اسٹیبلشمنٹ نے. چلو 50% تو دے دو نا ہمیں, کچھ تو ہماری بات چیت ہو. وہ بھی ہمیں انہوں نے 1958 میں جو ہے ڈپرائیو کر دیا اکتوبر میں, اور فروری 1959 میں الیکشن ہونے جا رہے تھے, قومی اسمبلی کے بھی اور صوبائی اسمبلیوں کے بھی. ان کو پریمپٹ کیا گیا اور بنیاد رکھ دی گئی مشرقی اور مغربی پاکستان کو آپس میں توڑنے کی. یہ ایک ابتدائی دور کی بات میں عرض کو کر رہا ہوں. تو پہلا ہمارا خوفناک تجربہ جو ہے وہ سن 54 میں ہوا, جس کے نتیجے میں بعد میں سمجھتا ہوں وہ ایک واقعہ ہے جو بنیادی واقعات میں سے ہے جو پاکستان کو توڑنے کی سبب بنا. اس کے بعد not very long thereafter, سن 62 میں جسٹس کیانی صاحب ویسٹ پاکستان ہائی کورٹ کے چیف جسٹس تھے. 62 میں جب وہ ریٹائر ہوئے تو ان کی جگہ چیف جسٹس لگانا تھا. سینئر موسٹ جج کون تھا؟ وہ شبیر احمد تھا. کیونکہ یہاں بہت سارے لوگ بحث کرتے ہیں میرٹ پہ نیچے کا بندہ بیٹھا ہوتا ہے. تو بھائی ساری تاریخ جانتی ہے کہ شبیر احمد کتنا اچھا جج سمجھا جاتا تھا, کتنا انڈیپینڈنٹ جج سمجھا جاتا تھا. اس نے اس وقت کے مارشل ایڈمنسٹریٹر کو عدالت میں سمن کر کے کھڑا کیا تھا. اس لیے اس بات کا غصہ ملٹری اسٹیبلشمنٹ کو تھا. انہوں نے کہا اس کو نہیں بننے دینا, اس کو نہیں بننے دیا. اور منظور قادر جو وکالت کرتے تھے ان کو لا کے ڈائریکٹلی چیف جسٹس بنا دیا گیا ویسٹ پاکستان ہائی کورٹ کا. یہ دوسری دفعہ سینیورٹی کے ساتھ یہ ہاتھ ہوا. بات میں کیا ہوا, جب 1 سال گزر گیا, جب اوور ایج ہو گیا, جب شبیر صاحب کی عمر 60 سال ہو گئی اس وقت کے حساب سے, تو اس وقت پھر ریزائن کر دیا ہمارے صاحب نے, اور ان کو ان کی جگہ پھر جو سینیورٹی پہ چیف جسٹس بنتا تھا عبدالعزیز ملک صاحب کو بنا دیا. اس وقت انہوں نے ریزائن کر دیا. مقصد صرف یہ تھا کہ شبیر کو کسی طرح بھی چیف جسٹس نہیں بننے دینا. منظور قادر اتنی دیر چیف جسٹس رہے جتنی دیر شبیر کی عمر پوری نہیں ہو جاتی. یہ دوسرا انسیڈنٹ ہے اور اس کا بھی نتائج آپ کے سامنے ہے. یعنی انڈیپینڈنس آف جوڈیشری کے ساتھ اتنا بڑا اس وقت کھلواڑ ہوا.
لیکن جو بحث آپ کا اپوزنگ کیمپ ہے وہ یہ کرتا ہے کہ اگر آپ صرف سینیورٹی کو فالو کریں گے تو آپ بیسکلی میڈیوکریٹی کو انڈورس کریں گے.
تو اس کا معیار کیا ہے؟ اس کا معیار کیا ہے؟ آپ کے سامنے جو بھی میں اگزامپل دے رہا ہوں اس میں میڈیوکریٹی نیچے سے اٹھائی گئی ہے. میں آپ کو ایک مثالیں دیتا ہوں. تاریخ کے حوالے سے بات کریں. ہوا میں تو بحث آپ جتنی جی چاہے کر لیں. امریکہ میں تو ویسے ہی چیف جسٹس جو ہے نیچے کی عدالت سے لا کے سیدھا چیف جسٹس لگا دیا جاتا. رابرٹس کو ایسے لگایا گیا. لیکن آپ وہ مثالیں نہیں لیتے جو آپ کی اپنے ملک یا اپنی جگہ کی, آپ کے اپنے ہسٹری کی نہ ہوں. اس لیے argument means nothing unless it is based on some substantial evidence, it is based on substantial historical experience. اس کے علاوہ تو ہوا کی ہے نا, جو جی چاہے بحث کر لیں, آخری ہی بہت اچھا ہوگا, یہ بات نہیں ہے. تو یہ میں آپ کے پاس پاکستان کی تاریخ کی مثالیں دے رہا ہوں تاکہ سب کو پتہ چلے کہ پاکستان کی تاریخ میں سینیورٹی پرنسپل جب بھی ایکسیپٹ نہیں ہوا ہے اس سے بڑی تباہی ہوئی ہے. تیسرا انسیڈنٹ, طفیل علی عبد الرحمان چیف جسٹس ہوتے تھے سندھ ہائی کورٹ کے 1975 میں. وہ فوت ہو گئے. اب اس کی جگہ چیف جسٹس مقرر ہونا تھا. نور العارفین صاحب سب سے سینئر جج تھے اس وقت سندھ ہائی کورٹ کے. جو میرے عمر کے لوگ جانتے ہیں, جو اس وقت پریکٹس میں تھے کراچی میں, وہ آج بھی اس کا نام لیتے ہیں. آپ پرانی ججمنٹس اٹھا کے دیکھ لیں. ہی واز ون آف دی موسٹ کمپیٹنٹ ججز آف سندھ ہائی کورٹ. لیکن اس وقت کی حکومت کو پسند نہیں تھی. یہ اس شخص کو بھٹو صاحب پسند نہیں کرتے تھے. He was too independent for their taste. لہٰذا کیا کیا، ان کو نہیں بنایا، ان کی بجائے سپریم کورٹ سے عبد القادر شیخ کو اٹھایا اور اس کو وہاں چیف جسٹس لگا دیا. اور عبد القادر شیخ اور نور العارفین نے کبھی مقابلہ کر لیں، ججمنٹس اٹھا کے دیکھ لیں، آپ کو پتہ چل جائے گا کون کمپیٹنٹ ہے، لیکن ڈپرائیو کیا. اگلی مثال وہ لاہور ہائی کورٹ کی ہے، جیسے آپ 1976 میں 5ویں ترمیم آئی تھی. 5ویں ترمیم میں انہوں نے فکس کر دیے تھے ٹینیورس، سپریم کورٹ کے چیف جسٹس کا اور ہائی کورٹ کے چیف جسٹس. لاہور ہائی کورٹ کے چیف جسٹس کا یعنی ہائی کورٹ کے چیف جسٹس کا 4 سال کا ٹینیور کیا، اور وہ ساتھ ہی سردار اقبال ریٹائر ہو گئے. اب سوال یہ ان کی جگہ کس کو لگایا جائے؟ چیف سب سے سینئر جج جو تھے وہ مولوی مشتاق تھے. ان کا ویسے حق بنتا تھا کہ سینئر میں اس کو لگا دیا جائے، وہ آلریڈی 14 سال سے جج تھے ہائی کورٹ کے. ان کی نسبت 8ویں نمبر سے اٹھایا گیا ہے اسلم ریاض حسین صاحب، جو تو میرے ہم لوگ جانتے ہیں وہ بیچارے ان کی کیا کوالٹی تھی ایز اے جج، اور جو مولوی مشتاق حسین کی